Hey everyone, so today we are going to be talking about the updates in US immigration. There's so much that has happened. I'm here to tell you about the pause on green cards for certain people, your social media being used against you, and all the other craziness that's going on in immigration. If you have questions, put them in the comments so that I can respond to your questions as I am going through these updates. Feel free to ask me questions. I do see there's already a question from Peace on Earth. Thank you for joining and asking your questions already. I will definitely be answering that. I just want to get into these updates first. So, if you are in the US, right, if you are in the US and you have refugee status, you came in as a refugee, or you won asylum in the US, and now you want to apply for a green card. Typically, you just have to wait a year after being physically in the US to be eligible to apply for a green card. Wow. The US government is now putting a pause on those green card applications. So you can apply, but they are not going to approve it anytime soon. So basically, there's a pause on approving green card applications for refugees and asylees, and there is no deadline, right? We don't know when they're going to decide that this is now okay and we can move forward with granting green cards to people that have shown that they are not a security risk, that they have went through years of processing to get their refugee status, to get their to get their asylum status, and now that they're going to apply for a green card, all of a sudden there's a pause by the U.S. government. So these people, unfortunately, that have an application pending have to wait because there's no way to speed it up. There's nothing you can really do when the US government says, hey, we're doing, background checks. We have to check everyone. We have to do this. Unless there's a lawsuit, that's filed and an injunction is put in place, meaning a federal judge has looked at the case and says, hey, government, you cannot enforce this executive order. Unless that happens, you just have to wait. Okay, they cannot, USCIS officers cannot approve green card applications for refugees and asylees at the moment. That may change in a few months or it may never change. We would not know. But that is a huge deal right now. I have people contacting me. What can we do? How can we, get my application moving? And unfortunately, there's nothing you can do. Okay. You can join lawsuits or not, right? You can join lawsuits. And someone is saying either you in or you out. Good luck. Well, here's the thing, right? People that are in the US as refugees were designated refugees by the United Nations. Then the United States allow them to resettle in the US as refugees. So these are not people that entered through the border. They're not, nope, they were legally given permission to come into the US and resettle here because they are refugees and they have went through years of screening by the UN, by the US government before they were allowed to enter the US. Asylees are people that apply for asylum in the US. They either went through an immigration officer that interviewed them, looked at all their documentation, and agreed that they qualify for asylum and gave them asylum status. Or they went through an immigration court and the judge went through their testimony, went through all their stuff, and decided that they qualify for asylum and gave them asylum status. So these are not people that are, here undocumented. These are people in valid status that are looking to now go from refugee status, asylee status to permanent residency. And these are people that the INA, the Immigration and Nationalization Act and Nationality Act, basically says these people can apply for a green card after they have been in the US for a year. That's what it says. And now the US government is putting a pause on granting them a green card. Okay, not because they committed any crime, not because they did anything wrong, just at the whim of the government. So when I am talking about this and people want to tell me that, well, they should have done it the right way, they did. Okay? They did do it the right way. They did go through the right process to be designated as refugees, to be given asylum status. And now they're just trying to move through the US immigration system to get their green card. And that is where the pause is. So I hope that was helpful to the person that said that. And you are now better informed on how refugees and asylees get their status in the US. All right. So the second group of people that have a pause on green card applications are people that entered through a parole program that was designated by the Biden administration. This is specifically targeted at Cubans, Haitians, Venezuelans, Nicaraguans, Ukrainians that entered under the U4U parole program. And then there's also people that entered through a parole program that's specific for family reunification. Yeah. So people that enter the US because the US government believe that they qualify for family reunification and they can get their green card in the US instead of waiting outside of the US. They can actually, these are people that have I-130s approved in their case, and the US government told them, hey, you can come to the US and wait out your green card here instead of being separated from your family. Those people now that are going to apply for a green card through that family member, their application is also on hold. And then if you got your parole through, like I said, the U4U program, the parole for Cubans, Haitians, Nicaraguans, and Venezuelans, if you got it through that program as well, which again, the US government went through a whole process for you to get that parole and enter the US and have the parole for 2 years. And the point of the parole, giving you the parole for 2 years, is that eventually you will adjust your status, change your status to something else, and be on a path to a green card. The people that are on a path to a green card are now being punished by basically taking away their ability to get a green card by putting a pause without a deadline. I want to make that clear. There is a pause and there's no deadline of when that pause will be lifted. So we're just going to have to wait for the government to eventually lift that pause. Okay. And then the final one that I want to bring to your attention, and a lot of people seem to misunderstand this. So the US immigration is now going to heavily scrutinize and review social media of applicants. So if you have a social media account and you're applying for a green card, a visa, whatever you're applying for, the US government is now going to heavily scrutinize what you post, what is available on your social media. Okay, so what does this mean? If you have any posts that disparage the US government and you are applying for a student visa, you may not get that student visa. Okay, again, because you're applying for a visa, you don't really have First Amendment rights because you're not in the US, right? So your speech from outside of the US can definitely be used against you here. But I want to make something clear though. The US government looking at your social media is not something that's new. Okay, it is not new. The USCIS officers have been looking at social media accounts of applicants forever. This is not new. I have had cases where we went to the interview and the officer mentioned the client's social media posts. So again, this is not new. It's just now they are giving USCIS officers authority to base their decision on that social media post. And the criteria they're using is going to be more expansive than before. So it's really important to note that this is not new. They've been doing this. It's just how it's being applied now is on a different level. Okay. If you have ever within the past 5 years applied for a visa to the US, an immigrant visa to the US. So you filed a DS 260 to come to the US. You know, on that DS 260, it asks you for your social media handles for the past 5 years. Whether the account is still open, whether you still have access to it or not, you are required to disclose it on that DS 260. Now, the Trump administration can choose to add this requirement into, you guessed it, the I-485 and every other application that you file with them. So be, you know, I am very prepared with my clients. We do talk about social media. When they sign on with me, they get an email with a whole booklet that tells them what, how their social media can be used against them and what to look out for. I may need to update that now based on the new guidelines. However, this is something that is not new. It's just the application is going to be more forceful than before. And it will be happening more than it was before. So, really want to mention that. And something people ask me is, what if I delete my social media? How would they know? Wow, they may not, but remember, part of applying for a visa, a green card, anything with USCIS is there's that truthfulness aspect, right? Have you ever concealed information? Have you ever misrepresented information? And when it comes to the social media, it's not the fact that they can access it that's really the problem. It's the fact that you out there will think, oh, let me just not disclose all my social media, or let me delete this account and not tell them about it. Let me tell you right now, deleting the account does not relieve you of the requirements. Like I said, with the DS260, it's for the past 5 years. So even if you haven't had the account for 2 years, you still have to disclose it. So it's really important that you kind of know that deleting the account is not enough. This is what I tell people though. You can make your account private, and you can make sure that the only people that you are accepting as friends are people that you truly do know in real life. Um, but again, want to make something really clear. And please feel free to tell me that I am a conspiracy theorist, because here it comes. Meta, X, all the social medias, right, are cooperating with this administration, and they have all your information. So, do I think they will share it with the government? You know, you use your own judgment on that. But my advice to my clients is, again, keep your account private. Do not accept friend requests from people that you do not know in real life. Okay. So having someone ask different name on social media, it doesn't matter if your social media handle is not your real name. Does not matter. You still have to disclose it. Okay. And this is the trap, right? This is the trap that they are setting for people, is for you to say no, that you don't have one. Then they discover that you do have one. And now they can charge you with misrepresentation, which means now you're going to need a waiver to get the green card or the visa or whatever it is, right? That's really my, again, conspiracy theories mind going, is that's really the goal with this, right? It's for you to say, oh, I don't have any, or to have a clean account, and then you're like fake account that you use to actually post and do all of that, and you only show them the clean account and not the fake account, and they find the fake account, and now misrepresentation, right? So they want you to fall into that trap. So do not fall into that trap. Your social media name does not have to be your real name, right? But you still have to disclose it. Really important. Okay. All right. So I see a lot of questions, so I'm going to get to those now. Remember, if you're joining me live and you have questions, ask them in the comments. More than happy to answer them. All right. So Peace on Earth asks, I got a conviction before I got my green card using the 601 waiver. Should I be worried about renewing my green card? It's assault with a dangerous weapon, and okay, it's an assault with a dangerous weapon and got 30-day suspended sentence in Massachusetts. So, is it considered an aggravated felony if less than 1 year sentence? Okay, so I'll take those in sections, right? I'll actually answer the second part of the question first. So, in Massachusetts, assault with a dangerous weapon, if you have a sentence of a year or more, is an aggravated felony. Okay. It could also be considered a crime involving moral turpitude, depending on what the actual facts of the case are. Now, it could make a person deportable if it is a domestic violence. Um, if the assault and battery was to a household member, then that would be um, a domestic violence charge that will make the person deportable. So there's layers. So when it comes to criminal convictions, there's layers to it. And that's why I always ask people for the court disposition, because I need to know exactly the section of the law that the person was charged under and convicted under. Okay. Because what you're charged with and what you're convicted of can be two different things. Okay, so that's one. But assault and battery with a dangerous weapon in Massachusetts, if you have a sentence of less than a year, is typically not an aggravated felony. However, depending on the facts, it may be considered a crime involving moral turpitude, or make you deportable if it has a domestic violence angle to it. Okay, now if you had this crime before you got your green card and you were able to file a 601 waiver for it, and the 601 waiver was approved, then the crime is waived. Okay, USCIS cannot come back when you go to renew your green card and bring that up. All right, so it's really important that once that crime is waived, you do not get any more crimes. Right, that's really important. If you haven't watched my video from Tuesday on the 4 ways to lose your green card, go and watch that. But once that crime is waived, USCIS will not use it against you again. It's already in their records that you have that crime, and it's already in their records that they waived that crime. So you want to make sure that you have all your documentation, the approval for the 601 waiver, the court disposition for the conviction, all of those things. You want to keep it for your records. But once it's waived. Okay, unless you get new crimes, then that's a different thing. But if it's the same crime that was waived, typically USCIS is not going after you for the same waived offense. Okay. Jay, hi, welcome. Kedokime. I hope I don't know if you speak Igbo, but you know. Zeus Publishers. I was here on an F1 student, but dropped out from school because I could not afford my tuition. So I guess I am out of status. Yes. Yes, you are out of status. I just got married to a US citizen, and I am thinking of working with my Social Security. Okay. Okay, because I need to pay for bills, and I know will be forgiven since my spouse is a US citizen. I check on the form I-9 that I have work authorization. Meanwhile, no. Okay. So one, on your I-9, you must indicate that you are not a citizen and that you need a work authorization. If you are married to a US citizen and they are filing for you, you can include a work authorization application with your green card application. So that way you will be able to get your employment authorization as quickly as possible. And finally, if you are applying for a work authorization and you have a job offer, right? That's really important. If you have a job offer that's dependent on you having that work authorization, you can use that job offer to then ask for an expedite of your work permit application. So that is a way that you can speed that up without having to just um, work without authorization. And they will probably get you a better result with employment. Okay. Um, Jay, uh, I wouldn't say so. I do. So Jay's asking if I have a lot of people that reach out to me for pro bono representation, and in my firm, I do pro bono representation through a nonprofit here in my city. So I do give give my time in that way, not through, not directly through the firm, but I do offer representation pro bono through the nonprofit organizations. So basically, in order for the person to be able to qualify for the services through the pro bono services through the nonprofit organization, they do have to show income. And most people that are going and looking for pro bono representation just do not have the funds, right? They don't have the funds to work with a lawyer. And going through the nonprofit, we get to help the most vulnerable in our community. So I do offer pro bono services if the person goes through a nonprofit and they are referred to me through that nonprofit. Hi, Charles. 2 children derive U.S. citizenship through their father as only dependent. Now, when the father petition for the mother, will that affect I-864 if I earn about 33,000 a year? So here's the thing. If the children are your dependents and they live with you in your household, they count as your household members. So it would be you, your 2 children, and the mother, right? Your spouse that you're trying to file for. So that's 4. That would be a household of 4. Regardless of the fact that the children are US citizens, it's about the fact that they are dependents. All right. So if they were green card holders, they will be dependents regardless, right? They will be part of your household size, even if they don't live with you. But because they're US citizens and they live with you, they would be considered dependents. Okay. Even though they're US citizens. Now, household of 4, you will need to go on I don't have it off the top of my head to tell you if 33,000 is enough, but you need to look at the poverty guidelines on the USCIS website. It will tell you your household size and the income you need for that household size. Okay. So it's really important that you look at not just, your spouse that you're filing for, but also the fact that you already have 2 dependents. So that's what you're going to look at for that. Okay. So I'm going to actually put this link in the chat. So this is the link that shows you if my stuff will work right now. So what I was trying to post was a link that you can use to see if you can. Okay, I guess I'm not able to do what I want to do right now. That's okay. But the point that I was trying to make is you need to look at the poverty guidelines and see if that would be enough. Okay. So since I'm already here, so for a household of 4, again, that's you, 2 children that reside with you and are your dependents, and the 4th person, the person you're filing for, that would be a household of 4. So for a household of 4, if you are not active duty military, okay, and you do not live in Alaska or Hawaii, you need a minimum of $40,187 to sponsor the person. And if you do not make enough money to sponsor the person, you can use a joint sponsor. Okay. And that is something that, a lot of people don't think about. But if you use a joint sponsor, then you are able to still file for the person, even though your income is not enough. Okay. So even though your income is not enough, they the person that's the joint sponsor, their income may be enough so that you, right? So then you don't have to make enough. So I hope that was helpful. I did put the link finally in the comments for how to check the income requirements. Okay. How long after USCIS receives your RFE response, you can get a decision? It really depends. There's no timeline, okay? If it's been 90 days since you sent it in and they have not responded, you can follow up with USCIS. But if they are doing any sort of investigation, there is no timeline, all right? And also you need to look at the timeline for the application that you're filing. So sometimes when you file an application, USCIS may ask for, you know, a medical exam report, or, hey, we need a copy of a birth certificate. That does not mean that they are about to make a decision. It just means your packet was incomplete and they need additional documentation to make your packet complete to then put it in line for an officer to review it. So you want to always start with what is the processing time for the application that you're filing. And if you are already beyond that processing time before the RFE was sent, then you want to check in with USCIS typically 90 days after. Because again, when you send in that RFE and it's gonna go through the system, get back to the file, and then that file needs to go back in front of an officer to review. So it's a whole process. Please, can you also explain Part 9 on Form I-485, number 58, indicate your annual household income? Okay. So your household income is the income of everyone that lives in your household. Okay. So if you are filing, to make this as simple as possible, if you are filing an affidavit of support with your I-485, typically that will have your household, that will typically be about your household income, what your sponsor's income is. So for example, if a husband is filing for their wife, but also living in their home is the husband's parents, right? The question becomes, are the parents considered part of the household or not? They're only considered part of the household if they are dependents or if they are willing to include their income as part of the affidavit of support. So typically for a household of two, where it's the husband and the wife, it would be the husband's income and the wife's income would be the household income, right? I will need to pull up the I-485 to answer the second question about the number 76 without more information, okay? But yeah, annual household income is about your specific household and how much income you are bringing in as a household. Okay. If you filed your I-130 in March 2024, how much longer do you think it will take to hear back? My husband is Canadian. So on I-130 right now, because I just had to check this for a client, it's taking about 17, the normal processing time at the moment is 17 months if your case is at a service center. If your case is at the National Benefit Center, it's more like 52 months, okay? So you want to know where the case is when you're checking the processing time, because that's going to make a huge difference, okay? People don't want to think about that, but where your case actually is physically located is going to make a difference on how quickly your application is processed. And then if it's been a year, so probably a few more months, okay? You have you have a few more months to wait. Okay, like I said, 17 months is the normal processing time right now if it's at a service center. Okay, um, again, that's assuming you only filed an I-130 and not a green card application with it. Okay, I want to make that clear. That is only assuming it's only an I-130 without a green card application. If you file the green card application with the I-130, you need to look at the processing time for the green card application, not the processing time for the I-130, because green card applications are handled by the local field office, not the service centers, okay? And each local field office has their own processing time because depending on where they are, they may either get a lot of applications or not a lot of applications. So it really varies when it comes to the green card application. All right. Okay. So those are all the questions I see so far. So remember, if you have questions, go ahead and put them in the comments. If you would like to have a detailed consultation where we actually like talk about your specific situation, feel free to schedule a strategy session with me or a detailed consultation with me. You can do either of those on my website, lilylegal.com /contact us. And on there, you can pick a date and time that works best for you for us to chat about your case. Okay. Now, all right. I don't see any other questions. So again, just to cycle through the updates, if you have refugee status or asylee status and you have a green card application pending, just know the adjudication, so the decision on your case is going to be on hold, okay? Officers are not going to make a decision on your case until that hold is lifted. If you are applying for a green card and you receive parole through the Youth for You program, the Family Reunification program, or the Cuban, Haitian, Venezuelan, and Nicaraguan parole program, again, these are 3 programs that were done under the Biden administration. If you applied through any of those, your application is on hold. Okay. If you're trying to go from that to a green card or that to something else, your application is on hold. Why? Because the administration believes there may have been fraud in the process. And if there's fraud in the process, they're just holding everyone's application while they do that investigation. And there's no timeline of when that is going to be lifted. So we are kind of on a standstill right now. And for those that entered the US with parole, but it wasn't under any of these programs, your case is still going to be processed. Okay. Your case should still be processed because they specifically named these programs, these parole programs in that. So other paroles should not be affected by this pause. All right. So, Malik, God forbid you get NTA after denial. Can you get detained at the court? So it depends, right? Typically, right now, what we're seeing with the court is people being detained at court is specifically if you have your final hearing and the judge does not approve your case, right? If the judge denies your case, we have seen them detaining people right after they walk out of the courtroom after getting that denial. So there is a possibility of that happening, unfortunately. There is a possibility. Okay. Do you work in Virginia? Yes and no. So I am physically based in Massachusetts. However, I do represent clients with USCIS and the embassy all over the US. So location does not really matter as long as it's a case with USCIS or the embassy. Anthony is asking, what about I-751? I'm not sure exactly what you mean by I-751. So typically an I-751 is a removal of conditions. So you're going from a green card to a 2-year green card to trying to get your 10-year green card. And not sure. If you're still here and you want to expand on your question, please feel free to do so. What should I do if if it is hard to get a joint sponsor. You can, if you can't get a joint sponsor, you can look at your assets to see if you have enough assets to make up the difference. So that's really the next option, is either you can have a joint sponsor, or you can use your assets to make up the difference. And typically your assets need to, the value of your assets need to be at least, trying to remember the last time we did that, at least 3 times what the difference in income is. Okay, so assets can definitely be used, and not just your assets, but the assets of the person you're filing for as well. Okay. Is it beneficial for an undocumented immigrant to file a tax under this administration? That's hard, right? Because if you are here and you're working, there is a law that says you have to file taxes. But I do understand the fear. I really um I'm struggling with that too. That's really all I can say, is I'm struggling with that with certain clients. If we are filing a green card application for the client, then the answer to that is yes, go and file your taxes. Um, but that's all I can say. Right? There's a struggle there. But at the end of the day, it's up to the client to understand that there is a risk involved and whether it is worth it to take that risk. Um, okay, so for an I-751, after waiting 2 years, they asking for more evidence. Yes, they can ask. They can send an RFE for more evidence on any case that you file with USCIS. Okay, so typically when you file an I-751, it takes time for them to get to it. Okay, I have cases where it's been 2 years and we're still waiting, right? So it takes time for them to get to it. So they want updated documents. So it's not just because you filed your I-751 doesn't mean that USCIS doesn't expect you to continue your marital relationship. So if it's been a couple years since you filed, they are allowed to ask you for more documentation of your relationship, okay? And you do have to provide it. Just know you probably have an interview. They are pushing for most cases to have interviews now. So just be prepared for that as well. The I-485 and the 601 not processed at the same office. It depends sometimes. So if you are filing the 601 application at the same time as the 485, then it may end up in front of the same officer that will then decide your green card application. Okay. It may end up in front of that officer. However, if let's say you already filed your I-485 and now the officer sends your notice of intent to deny, asking you to file a 601 waiver, you are sending that application to a different office. It may circle back to the officer that's deciding your I-485, or that separate office may be the one making the decision. So it's really important that you don't assume that it's going to go to the same place, okay? Do not assume that. It may end up in different places. So when we file our I-485 and our 601 waivers together, we separate the evidence, right? Because sometimes the evidence for the 485 and the evidence for the waiver are the same, right? Your passport is your passport, your birth certificate is your birth certificate, but we still separate it just in case the packets are sent to the different places, right? So when we send it out, we make sure that the I-485 section of our packet has all the documents that will be needed for that I-485. And then when we do the 601 packet, we make sure it has all the documents and evidence required for the 601 section of that packet. We do not assume that it will go to the same office, because if it's separated and sent to different offices, we don't want one officer to be like, well, I'm missing all of these documents when we included it just for the I-485 section of the package. So there's no assumption, okay? So even if you send it at the same time, there is no assumption that it will get to the same that it will get to the officer. Okay. And the only reason I'm mentioning that is that you need to be prepared for it not to go to the same place. And make sure that your packet is set up in a way that it can be separated and still be complete applications on their own. All right. All right. So I do not see any other questions. Please feel free to let me know in the comments if you have any questions. If you're watching this on the replay, as always, ask me questions. And then next week, we're going to do just straight up Q&A because I've gotten so many questions that replying to them one on one is going to take forever, but I can at least do them on a live. Okay, so feel free to come next week, ask me questions. I'll be answering a lot of questions next week. So feel free to come with your questions. I always say this, and people always are like, oh my goodness, I know this may be a silly question, but there's no silly questions, okay? There is no silly questions. Immigration right now is crazy, even for us lawyers, okay? We are getting new information all the time, and things are changing constantly. So there's no silly questions when it comes to US immigration. So feel free to ask me questions, and we will keep working together. USCIS is not going to refer you to ICE after denial. That is a possibility, right? There is an NTA memo, so notice to appear memo that has made the rounds to USCIS officers that they should be putting people in deportation proceedings if their applications are denied. Okay, so there is a possibility. I can't say like, oh, these group of people are going to be put in there more than others. It's just there is a possibility that USCIS, if they deny your application, will put you in deportation proceedings. And that's why I tell people it's really important. The preparation for filing is so important now because you need to make sure that you have all your stuff in place to make sure that you are putting your best foot forward. Okay. Will USCIS know if work without authorization if I don't disclose it? Why would you do that? Okay. Why would you not disclose it? First off, if you are the immediate relative of a US citizen, working without authorization is not a problem. So why would you not disclose it? That's my question. All right. Um, One thing I always tell people, because I have people that come to me and they're like, oh, but how will USCIS find out? USCIS is part of the federal government. Okay. USCIS is part of the federal government. So as much as you want to act like you don't, Big Brother is not watching, Big Brother is watching. And especially when it is not something that will make your case be denied, why would you not disclose it? Okay. This is one of the few places where I would fight with my clients because they'll be like, well, how would they find out that I worked? How would they find out? From you. That's how, right? Because if you go to your interview and they ask you if you've ever worked in the US and you say no, if they ever find out that you lied, now you have a misrepresentation. Now they can try to take away your green card if they issued you a green card. You want to This is not the administration to play games, okay? This is not the administration to wonder how would they find out. They are asking you for your social media accounts. They are denying cases based on social media posts. So yes, disclose it, please disclose it. Okay. Ooh, all right. Uh, I'm just gonna switch my cameras real quick because I don't know what just happened, but something happened and my camera went out on me. So switching to a different one. So yeah, please, if the thing does not make you deportable, disclose it. Okay? If the thing does not make you deportable, does not make you inadmissible, disclose it. And how would you know that it doesn't make you deportable or inadmissible? Your lawyer should be telling you that. Okay? And if you are the spouse of a US citizen and you are filing a green card application and you have worked without authorization, it does not matter. It is waived. So disclose it. All right. All right, Charles. For immigration officer and immigration judge to approve asylum case, which of it can easily be revoked? This, I'm not sure if I understand the question, which can be easily be revoked. If you apply for asylum and you didn't qualify, I'm not, again, I'm not clear on the question, Charles. Which of it can easily be revoked? If a judge grants you asylum, you're an asylee. If a judge, if an officer grants you an asylum, you're an asylee. Unless you do something that makes it seem to the US government that you are no longer in fear. So traveling back to your home country, things like that can cause your asylum to be in jeopardy. But I'm not clear on your question. So I hope I hope that was helpful. Can you explain why judge go by the book and USCIS by discretion? Because USCIS is written in the INA, right? And I should mention that some of what immigration judges do are by discretion as well. So it's up to the immigration judge to make a decision of whether a person is credible, meaning, do I believe what this person is saying? Do I believe the evidence that this person is presenting? That is not like by the book. I want to make that clear. That's kind of the judge making an intuitive decision based on what they're hearing and all of that to decide that this person is telling the truth or not telling the truth. So there are certain things, and also, right, when you make an argument in immigration court, the judge still has to make a decision of whether they believe your argument or whether they side with your argument over the government's argument. So there is discretion, right? It's up to the judge to decide the case. So it's not really, there are rules of how things go in immigration court, but there's no, specific rules that if X, Y, and Z is present, then the judge must approve the case, right? That's a different situation. Just like with USCIS, there's only like one or two places where it will say if X, Y, and Z is in place, they must approve. For the most part, it is discretion based with USCIS and with the judge. Okay. Can you help with a charging document from Mass Court from 1993? It depends on the court, and typically those are in archives. And if the court has not digitized them, then you would need to go to the court and ask for those documents. But it is possible. It's just sometimes you would need to kind of call ahead and let them know what documents you're looking for, and if they can find it in their records and they have the physical file. I have done that for a case from the 80s in Massachusetts, so it is possible. You just have to plan ahead for it and not just show up to the court and think they're just going to have it right there and ready to go. The older it is, the harder, the longer it takes them to find it, especially if they've put it in the archives. Again, Malik, it just depends on the facts of the case. So he's saying some cases you have more of a chance with the judge than USCIS. Here's the thing, right? Here's the thing. There's certain things that you cannot apply for with USCIS that's only available in immigration court. For example, cancellation of removal is only available in immigration court. If you received your green card, but there was a fraud, and then it's found out at the citizenship stage and they put you in immigration court, you may be able to file for a fraud waiver that does not require you to have a US citizen child, parent or spouse. You can have a U.S. citizen child that, and then you can get that waiver. So there may be more things available to you in immigration court than with USCIS, depending on your particular situation. Okay, everyone's case is different. So saying like, oh, some cases, not every single case type is going to have a better chance in immigration court versus in Massachusetts, versus in USCIS. Okay, so you really need to be clear. And I try to avoid my clients being in immigration court as much as possible, because if they lose their case, they now have a deportation order. Okay, if they lose their case with USCIS, and they're put in immigration court proceedings, at least they get another shot at it with the judge. Okay, so you see the difference there. So sometimes, depending on the person, depending on the person's situation, being out of immigration court proceedings may be the best option for them and the most beneficial option for them. So it's really just about, at least in my practice, doing the best thing for my clients. So a client may have, an option of doing cancellation of removal in immigration court, but they have children and they want to stay with their children. The goal may be to get them out of immigration court and file with USCIS instead of with the court, just so they are not in a constant threat of deportation. Okay, so that's kind of the decisions that we make when I'm working with clients, to figure out what is their goal, what is the most important thing to them, and the best way to get them there. Because if you file with USCIS and you lose and they put you in immigration court, you still have the option of doing all of those things in immigration court, right? That you would have done if you were in immigration court to start with. But that may not be the best thing for your family and for yourself. So we kind of make that decision on a case-by-case basis. How can I get arrest records in Massachusetts? It depends. It depends how long ago it was. If you're looking for the arrest records, if the person was not charged and there's no court records, the arrest records would be with the police officer, the police department. So in Massachusetts, we do have a online public records request. So you can request if you are the subject of the police report, you can request that online. Even if you're not the subject of it, you can request it online, but it may be redacted depending on the situation. And then if it's a domestic violence based offense, it will not be on the online records. You may need to go in person to get those. But the actual arrest records, if they're not part of the court records, will be with the police department. But if the person was charged, it may be easier to get it from the court, because typically the court will also have the arrest records. So depends on what exactly you're looking for, will determine how you go about it, whether you go straight to the police department or if you go to the court. But the police department will have the records. And then if the person is charged, the court may have the records. Okay. And remember, things may be in the archives, so you need to give them enough information to find it and enough time to get it to you. All right. So thank you all so much. Like I said, next week is Q&A. So bring all your questions. If anything changes in immigration between now and then, hopefully not too much, but any changes, I will let you know about it. But definitely join me next week where we will go over a lot of the questions that I have been receiving and your questions as well. So thank y'all so much for joining me. Remember, as always, if you want a strategy session, it is a free 15-minute time for us to talk about your particular situation. Remember, on these lives, I can only answer general questions. I can't really speak to your particular needs. So that's what the strategy session is for. So make sure, if you would like a consultation where we're digging into your particular situation, schedule a strategy session, and you can do that on my website, lilylegal.com. Click on contact us, and you can pick the date and time that works best for you for us to chat. And if you are still on this live and you have not liked this video, please go ahead and like it, especially if you have gotten value out of today. Thank you so much, and I will see you next week. Bye.